I'm Tom Rice. I'm chairman of the DUI Recidivism Study Committee, and welcome you all here this morning. Thanks for coming. I know a lot of you here to speak on the subject today, and it's good to have you with us. Just by way of introductions, I think you probably all know who's sitting up at this dais. But on my right over here is Jay Powell, Chairman Powell. We have our inestimable new father with us here today, Dusty Hightower, and congratulations to you and your good wife. My good friend Barry Fleming from out Richmond Way, and Regina Quick from out in Athens, and Tim Barrs are joining us today too, kind of ex officio down there. Matt and Craig down there are keeping us all straight. So that's the team for today. I'm gonna just ask you, Barry, if you would just give us a word of prayer to start off with. You on 20.
Absolutely. If you bow your heads with me. Lord, we pause now and we recognize and thank you for allowing us to be here today. We ask you, as always, to give us, the members of this committee, the wisdom that we need to do the work of this House. We ask you on this subject matter particularly to enlighten us and lead us in the right direction. We thank you, Lord, for this freedom that we have to meet today as part of our republic, our democracy. We know, Lord, that the ability to be here is because many a man and woman have given their lives, paid the ultimate sacrifice for our freedoms that we enjoy. And currently, Lord, we know that's going on not only in this country but around the world. We ask you to bless those that stand in harm's way on our behalf. Thank you for this day. Bless us and keep us. Amen.
Amen. Amen. This subject is one that gets constantly revisited, and it was last revisited in 2012 when the Title 40 Study Committee met, and the DUI issue was considered as part of it. Out of that committee came House Bill 671, which occupied the Judiciary Non-Civil Committee last year for a great deal of time, and they did a great deal of work on it, and I appreciate all the effort that went into it then. Did not make it out onto the floor for a vote, and we're here to focus specifically on that topic today, and not all the rest of the things that went into that Title 40 671 bill. By the way, just for the record, most of the other stuff that was in 671 did happened to pass in a Senate bill that we managed to work out. But anyway, we had some profit out of that. The other thing I want to mention is that this is obviously a difficult area of the code, and I know Jill Travis and Jen Doldy, the Legislative Council, have worked on this diligently, and so the complexity of the issue and the serious nature of the issue makes it a really compelling thing for us to be attentive to. And we're going to start off. I'm going to ask Dusty Hightower to talk to us about what the Judiciary Non-Civil Committee came out with, basically, and the issues associated with that as we went through this last year. Dusty, you're on 21.
Yes. Thank you, Mr. Chairman. I spent yesterday, Chairman Golick and I spent about 30 minutes on the phone going over kind of the issues that he wanted me to bring out. He was going to be presenting this today, but I believe he has a funeral that he has to be at, and so he gave me some talking points to go over. So I hope I do him justice by being his mouthpiece today. Some of the issues, and really what he wanted me to do is not necessarily go step by step through the bill, but just give you all the broad strokes of what we thought the big concerns were and what kind of slowed us up. And what our big talking points were when this was coming through the Judiciary Non-Civil Committee. To start off with, there was a consensus that we did want to be stronger and have a stronger sentence or something that be a little more aggressive for those that refuse to take the blood test. And that is something that we all had a consensus on, that we really did want to be a little more aggressive with those that did refuse the state test. But with that, we also had to strike some type of balance, but because we realized that just 2 years ago, I think it's 2012, that before on a second DUI, it was a second DUI, your driver's license was restricted for 1 year automatically. It was a hard suspension for 1 full year. We had a lot of committee meetings. A lot of people came and addressed the issue. I believe Matt even came and didn't speak against what we had changed, but the change was that we changed that 1-year hard suspension to 4 months. And now on a second DUI, within 5 years, your license is only suspended for 4 months instead of 12, but then you now have a 12-month interlock device in your car, and then you have 2 months of a permit. So it went from a 12-month hard suspension to an 18-month some type of regulation on your driver's license. And so it really didn't make sense to just do a refusal on the first and completely throw their license away when we had just 2 years prior said, well, that doesn't really work on a second. So we were trying to balance that and find a balance there. One of the things that we proposed or that was talked about, I don't think it came out fully vetted in the committee, but one thing is that on a refusal, if we did do a hard suspension on a refusal, that you may be able to petition the court for an interlock device on the first. So if we were to, and again, these are just ideas that we were talking about, but if you did do a hard suspension on a refusal on the first, then you could allow someone to petition the court to have an interlock device. Now, a lot of folks on the committee got the impression that a hard suspension doesn't really happen. In other words, on the roadside, you refuse, and the law says, a lot of people thought, well, if you refuse, you lose your license for a year. And for those of us that practice DUI law and prosecute DUI law, like Matt Krull in the audience today, we know that's not really the case. There are hard suspensions for refusal, but it's not point blank every time you refuse, your license is gone for a year. So we had come to different discussions about possibly looking at the new way that we affect your driver's license on a second and 5. Maybe on your first time DUI, if it's refusal, make that be the restriction on a first. In other words, if you refused on your first DUI, then as a sentencing process, I'm leaving the ALS hearing to the side now, guys. I'm just talking about sentencing, okay, because we know that there's 2 different areas here. We're going to leave the ALS to the side for a minute. But as part of your sentencing, if you were a refusal and you went and you pled guilty, part of your sentence would be that you'd now have a 4-month suspension, 12-month interlock device to your 2-month permit, like a second-time DUI license would be, just for refusals. But when the chairman and I started discussing that, one of the precautions that I set out there to him was this. I said, if we make that the rule, we may very possibly take a very big bargaining chip out of law enforcement's hands. And here's why I said that. If we made that the rule on refusals, then at ALS hearings, bringing the ALS hearings back into the picture, the officers now, if you refuse to take the breath test and then you appeal, you do your 10-day letter, and you go to your ALS hearing, the officers can use that as a pretty big bargaining chip against you. And they can say, well, if you work with me, which means if you agree to plead the DUI, I won't suspend your license. And I told the chairman, I said, if we change this and we say we're going to change it to 4 months and make it like a second-time DUI for a first-time refusal, if we effectuate that, it could affect how much impact an officer has in an ALS hearing. Is everybody kind of following that? Because now they only have a 4-month bargaining chip in their pocket instead of a 12-month bargaining chip in their pocket. Is that everybody following that? Mm-hmm. And I know it can get kind of confusing because in DUIs you're dealing with 2 different systems. You have the court system where you're prosecuted for criminal charges, then you have the ALS system where you're administrative license suspension hearing where you're dealing with your driver's license. All right, so I know it can be kind of convoluted. So that's one of the dilemmas we were trying to overcome. We want to be stricter on the refusals, but we were trying to make it where it was actually effective because we know that on refusals now there's not technically a 12-month suspension that always happens. So we were thinking about some way changing that where the penalty actually is a penalty for refusing. But if we were doing kind of what we thought about, we also knew that law enforcement may not like it because we would be taking a big chip out of their pocket at the ALS hearings because they would not have 12 months anymore. They'd only be bargaining 4 months. And also, if we did stick with some type of a refusal and a straight restriction, we were contemplating again having where they could appeal the court to have some type of interlock device in their car and get them driving. And again, that related back to what we did 2 years ago and getting people back to driving with some type of interlock device. The other thing that we talked about was saying that we were going to put a level on what you blew. In other words, if you blew a point, I believe it was a .15 or .15, that may trigger the requirement for an interlock device for 12 months or for some period of time, 4 months, whatever the case may be. But if I'm not mistaken, we had pushback from that, from multiple different groups that were saying, you know, it would be easier if we just had a rule, not these different levels where, oh, if you're a point something or a point something else, that everyone's having to figure out what it is, and people didn't like it. A lot of different groups came to us and told us they really did not like that concept. That if we're going to be stricter on it, just be stricter on it across the board. They really weren't interested as much as, okay, well, a .15, we're going to treat it differently than someone who's a .149. So that was one of the things that we got some pushback from. The other thing that drew a lot of attention, and this is one that the chairman and I spoke about yesterday, and a lot of people know how I feel about it, and I know law enforcement in my own area is very pro with this, is the forced blood draws on refusals. Chairman Golick yesterday, just so everybody knows, is not just Dusty Hightower's issue, because it kind of got painted that way last year, and that's not the case. Goodness gracious. But the chairman said that he just wasn't comfortable with it. All right, and I'm speaking for him today, not just myself. And that's something that we're going to have to address and talk about. All right, is the forced blood draws on refusals. And what the chairman expressed to me, he said, well, one of my main concerns is we have such heartburn about taking a DNA swab that we don't even do it until someone is convicted of a felony charge, but we're going to allow these blood draws on a misdemeanor. You're just allegedly or supposedly accused of a DUI, but you're not convicted, and we're going to allow someone to go in and forcibly draw your blood. And in our conversations, what he asked me to do is he wanted me to tell prosecutors, law enforcement today, tell us why you need it, is what he said. He was saying, tell us why that, if we don't even do that on felony cases until you're convicted, why is that needed? All right, now, obviously you can see where kind of our heartburn comes in on a little bit of that. But also, it seems to go against a lot of the other statutes and the fact that we have a right, you know, that you can refuse, and then we have the ALS hearings and all those procedures on if you refuse. But if we have all that law that's there, but then when they refuse, we just turn around and say, well, we're going to get it anyway. We got to make some type of balance, because it doesn't really make sense to say, okay, we're going to allow you to refuse in the code section, and we have all this case law and code law or statutory law about these refusals, but then as soon as you refuse, we just turn around and go and get a search warrant. So he said, tell us why you need it, tell us how it can be justified in comparison to what all the law is out there, and why do we have it that you can refuse if we're not going to use any of that law anymore? Because we're really not if we do this. I believe that goes over most of what he asked me to talk about. I wrote some notes yesterday, and I think that was about it. I may miss something and may have to speak up a little bit later, but those were the big points that he wanted us to address, and he asked me to talk to you guys about.
Okay, thank you, Representative Hightower. Appreciate your commenting on that. I remember most of that from being at all those meetings, and I appreciate you summarizing that. Just by way of information, the October 9th meeting is really going to be where we're going to ask the Prosecuting Attorney's Council and the courts to come back to us, and on some of those issues, I think we'll have more opportunity to explore them. The purpose of today's meeting, basically from the agenda standpoint, is to find out, for the committee's purposes, what's going on, particularly around the country in different venues and in different states in terms of how they're approaching this problem. This is you know, the DUI issue continues to be a high visibility issue across the states. Whenever somebody has an accident, it's always that results in a death or injuries from DUI. It's always going to make people cringe at the possibilities of what that's all about. And so we have a lot of people on here today who are going to speak to various ways that to address this particular issue. I'd encourage the committee members to light up their microphones if you have a question, and we'll proceed to go through them as we can. Been joined today by Chairman Powell. Thank you, Chairman Powell, for visiting with us today. I know this takes you away from a golf tournament that that the majority leader is running today, and but you had one yesterday, so you know you can't have two in a row. So anyway, I feel good about this committee. By the way, I just want you to know that you know it's the first time I've ever served on a committee where the appointed members of the committee, there's 5 appointed members of the committee by the Speaker's office, where 4 of them are lawyers, and one is, well, kind of whatever you want to call them, but, you know, a lot of different experiences. So I just want you all to know, committee members, that I feel like it's about equal now.
That may be the reason they put a couple of non-lawyers.
All right. Well, with that bit of collegiality, we'll get started. First to testify would be David Pratt. I'm sorry, Bob Dallas. We made that entry on this after it was printed. Bob Dallas is going to talk to us basically about the metrics of where we currently stand in DUI right now, and he's provided some information that you'll find in your folder. I think it's a one-sheeter basically that talks about the counts in terms of the number of offenses. And Bob, if you'll tell us a bit about this. Bob is formerly the director of the Governor's Office of Highway Safety. Harris Blackwood couldn't join us today, and so Bob is going to kind of fill into that role. And we appreciate you coming today, Bob. Why don't you tell us what you have for us?
Members of the committee, it is my pleasure to be here. And of course, we're addressing one of the most preventable crimes in Georgia today, and that is impaired driving. And with respect to Director Harris Blackwood and Governor Deal, I just want to point out that the work that they have done has been incredible in terms of the numbers. And it's incredible in the sense that if you were to look at it from a, you know, could you reduce deaths that well over a short period of time? Most people said no, but they did. And let me just give you the numbers for the past several years. In 2012, we had 1,198 crash deaths. In 2013, we dropped that number to 1,187. Looking at 2014 year to date, it's 650. Compared to this time last year, that number was 766. And the reason is because the office has done a great job with pulling partners together under one common moniker, and that is towards 0 deaths. For the simple reason, you know, which life do you want to have killed on the roadway? And the answer is none. But with that, they have focused in on 10 different emphasis areas in their strategic highway safety plan. And one of the primary ones is the alcohol-related one. And let me just give you some of the numbers of crash deaths that involve impaired drivers over the years, so you can see how we have focused on this and we have done better. In 2005, that number was 433. In each of these are the following years: 2006, 454, 2007, 445, 2008, 405, 2009, 333, 2010, 298, and 2011, which is my most current number, is 277. So the state's been doing a great job with respect to pulling resources. Now, having said that, then the question becomes, how do we do better? And one of the things that we as a state have to look at is, where are we with citations? Where are we with the system that we have? And in front of you, there should be this chart that has the citation data from the Department of Driver Services. And this is raw data, so as such, it is not presented in a analyzed form. But what you see there are the total numbers, which I would turn your attention to in each of the columns. And in the first one above, you see the number of convictions processed in 2011 at 37,363, 2012 dropping to 33,973, and in 2013 that number continuing to drop at 31,825. There could be a lot of reasons for that, but what we have seen is that the number of convictions processed, this is as reflected by the Department of Driver Services, has gone down. And then when you look at the suspensions, you see similar kind of data. that if you look at the first DUI offender in that first column, it goes from 52,999 in 2011, and it drops significantly by about 7,500 in 2013 to 45,195. So what you're seeing is that in terms of the system in serving as that net to catch offenders, that there have been declines. So with that, the Highway Safety Office has always done a great job looking at data and identifying best practices, which is in great part why we're here today with the continuation of the assessing what the best practices are that have worked elsewhere that are data-driven results. And so you're going to hear from many a speaker talking about it from many different perspectives, and that is with good laws on the books, good enforcement strategies, and tools such as the ignition interlock devices used effectively, we can do two things. We can reduce the number of first-time offenders, but more importantly, we can address that multiple offender, which obviously as a repeat offender has a high proclivity to continue drinking, knowing the full consequences. And so with the ignition interlock devices, we have felt that it is a tool that has worked elsewhere. It's a cost that's primarily borne by the offender, and it provides a lot of flexibility in terms of addressing a problem so that this state can continue to achieve its overall objective towards zero crash deaths on the roadway. So, Mr. Chairman and members of the committee, hopefully this chart will be helpful in getting an idea of the scope of citations today, and hopefully the testimony of the people that will follow will show examples elsewhere that have addressed it and have provided proven results on crash deaths and serious injuries due to impaired driving.
Thank you, Bob. I appreciate that. There's a question from Chairman Powell.
Yes,
Thank you, Mr. Chairman. Do you have, or can you furnish us the data for the same years you're talking about as far as the number of DUI citations issued? Because when we're talking about convictions, we don't know if the number of citations have gone down or whether they're just being, some of them pled out to reckless driving, et cetera, so that they're same number of cases, but there are only fewer dispositions under DUI.
I will qualify with this. During my tenure, I was unable to get a good handle on that data. I do not know if since, and perhaps one of the subsequent speakers can identify. I'm seeing kind of a no shaking of head. The ability to capture the upfront citations issued data by category versus their disposition has been somewhat of an enigma in the state. A lot of it has to do with the many jurisdictions that we have using different systems with different courts. And capturing that collectively, and whether it's through the Administrative Office of Courts or through other agencies, has been difficult. So I think it's certainly the kind of data that would be probative for your very point, so that we can hone in on where perhaps issues are. But I don't gather, based on the experts' heads shaking their head, no, we don't have that data as you would like it and as I would like it.
Well, I guess my concern is because I know it's happening, and you know it's happening, but my concern is that sometimes what we do as far as, you know, decreeing license suspensions with no discretion to the courts is that if they feel like that they need some discretion, then what they're doing is they're pleading it down to something else. And not necessarily because that's wrong. It's just because we've tied their hands. And so sometimes what we do is we think that we have got, that we're going to solve the problem by throwing the book at somebody, when perhaps maybe we ought, because I know in my area of the state there's no public transportation, and the judges take that into account as far as these automatic suspensions, because they realize that means loss of job, you know, people going on welfare or whatever it may be. And so they craft their own remedies, which may be interlock devices or whatever. And but we've got no idea of what is happening out there because we aren't capturing the data, and that's my concern.
May I respond to that concern?
Yes, sir.
I think you hit the nail on the head of a major concern of many of us in highway safety, and that has to do with the ability to craft a solution that works for the offender, but works for all of us on the road driving lawfully. And that's really where the IED comes in terms of giving the offender the opportunity to drive 24/7 wherever the offender needs to go, maintain a job, maintain a family, do all those kinds of things that we need to have in a mobile society like ours, while at the same time ensuring, for the most part, that that offender doesn't hurt us again. And so you hit the nail on the head, in my opinion.
There are some other questions too, but on that particular point, Mike, you shouldn't have shown up today, I guess, because I saw you and I know you've spent some time on this. When we went through this issue before, there was a study that was done of misdemeanor minor traffic offenses for the other study committee that you guys, well, I guess it was the criminal justice reform issue, and there was a study that was commissioned of the different, I think about 3 different circuits or jurisdictions in the state. And I can't remember whether there was any data that spoke to the question that Chairman Powell had or not.
Mr. Chairman, if I may, if you could step to the microphone, because we are
Sure.
streaming live over the internet.
Okay. All right.
What's it here? Okay.
Mike, why don't you introduce yourself to our good friends here? And
Well, thank you. I do see a lot of friends on the committee today. I'd like to say hello and introduce myself as Mike Cucaro. I work for the Judicial Council and the Administrative Office of the Courts in Governmental Affairs. To answer your question, the AOC did commission a study with Applied Research Services to study in detail information regarding how the traffic citations work in their courts. They were primarily focused on low-level offenses, but we did get some idea of how cases are processed. I can go back to the researcher that we hired and ask him. He's also under contract with Department of Corrections and probably knows more about criminal justice data than anyone in the state. If you'd like, I can take that back to him and ask him, using the resources from our study, which he still has, plus his wealth of knowledge about the felony system, we may be able to provide some answers to this.
so the
committee.
focus on the citations would be, the issue here, I think, in terms of Chairman Powell's question.
I would hope that GCIC is capturing, through their offense tracking, some of the citation information. We can find out if that is being tracked by anyone. I know that we don't have it, but I would certainly agree that that's crucial to your question. Chairman Powell has hit the nail on the head. I agree with everyone here.
Thanks, Mike. I appreciate you. I appreciate you coming over today. You never know what happens when you get to one of these meetings, do you?
Well, I am happy to be here.
Okay,
So,
good.
Thank you.
All right. Mr. Dallas, there are a couple other questions for you. Representative Quick had one. And by the way, we've been joined by Chairman Setzler. Chairman Setzler was the subcommittee chair for the Judiciary Non-Civil as we went through the 671 bill last year. Welcome. You're on.
Thank you, Mr. Chairman, and thank you, Mr. Dallas, for the information. I was wondering if you had similar data and have perhaps collected a range of total fines and surcharges for DUI offenses that are imposed against offenders across the state.
I'm aware of the fact, of course, that there are a number of different fines. I say they had a fine, but the different surcharges that apply. I do not have that bottom dollar amount. I do believe that's available, and that is administered and made available to the legislature in terms of the appropriation process. Those collected, it has to be appropriated. I think that hopefully one of the folks here can help us get that. But I think that's very good information, because perhaps expanding your question a little bit, it's often raised for the offender, are we pricing the offense at a level that perhaps causes people to engage in behavior that we don't want? For example, are they not doing this because it costs them money? Or are they paying too much for their lawyers? And I think Chairman Powell has brought that up in many instances. So I think the idea of knowing exactly what the surcharges are associated with this offense is a very good one, and that should be provided to the committee. I just don't personally have it now, not being in the office, but I think it is available.
Thank you.
Bob, would you move the microphone closer to your
Yes, sir.
mouth a little
Sorry.
bit so we can hear you a little bit better? And for the purpose of the committee, when we did the Title 40 study a couple years ago, there was a DDS presentation that was done that Representative Quick had the code sections and the fines and the reinstatement penalties and things like that available to it, which we'll make available to the committee. It's not goes to your question in terms of what the costs were totally, but it is helpful maybe. Okay, Representative Fleming has a question for you.
Thank you. We're all aware that there's been a focus in recent years on something most people refer to as accountability courts or drug courts. And I was looking at your statistics of second DUIs and as well as several of the other statistics that has gone down. Any relationship that you see between the bigger emphasis on accountability courts and drug courts and the issue that we're here for today? Anything happening in connection with those two?
Well, being a fan of the DUI court, because I was involved with this implementation in Georgia and seeing how it works for the multiple offender, I certainly see it as to those people involved as hopefully in the data that's proven it out, they're not going to become recidivists. I think the numbers of people involved in those courts are still relatively small throughout the state. So I think that alone would not explain this difference in number. Those courts work so well because they truly are accountability courts where you have a judge, a prosecutor, probation, and law enforcement doing random checks. Now, I will just transition that one of the reasons it does work is because of that randomness and knowing that if you fall off the wagon, you're going to be held accountable. In a sense, that's what the ignition interlock devices do so well, is that 24/7 across the board in a very cost-effective way, that offender can be held to account during a period of time that they may be able to change their lives. I wish we could have accountability courts for every single offender, but then the numbers would never allow for that because of the high overhead associated with the multiple offender. And it does work.
Thank you.
Okay. Any other questions for Mr. Dallas? I was just thinking back to our former study. There's been a lot said on this particular topic in terms of the numbers and why the numbers are coming down. I know that there are some people here from GUARD, the schools that do DUI schools, and just for anecdotal data more than anything else, it's and I've heard from public safety on this also that an inhibitor to citations and this process has been basically the ALS procedure and the amount of time it takes to for the enforcement organizations to appear and to be contested in those areas, and therefore their subsequently reduced number. So the question really is there really a reduced number of DUIs, or is the enforcement side of it just not performing as it was? With all the budget pressures and things like that, that may be the case.
I mean, all I know is what the numbers are here. I can say that during my experience as highway safety director and talking with whether sheriffs, chiefs, or state patrol troopers on the road, it takes a very dedicated law enforcement official working with a very dedicated prosecutor and a very good judge to hold an offender to account within the system. And, you know, we step back and look at this as some kind of random event. It is not. These are people who are out there interdicting impaired drivers. But when the system, and I've heard this repeatedly amongst law enforcement, makes it so difficult for them to go through the process just as you have described, then sometimes based on a host of reasons, including their resources, their time, and their desire to get more people off the road, you'll see where, whether it's a reduction or, quote, the deal at the ALS hearing to make it easier to process that individual, but not necessarily with a DUI conviction, happens. So the question becomes, how do we develop a system, and I think this is why this committee is so darn important, that ensures for these offenders that there's something in place that works, that data shows it works. One thing that data shows does not work is simply saying your license is suspended, because what ends up occurring too often is that individual makes a hard choice, maybe, but they go out and drive, and they drive with the same habits that they had before, becoming that recidivist. And that's a huge problem, I think, for not only this state, but for every state. And so states that have invested in really good laws that support the technology that's readily available have seen significant reductions in recidivism. You'll hear more about that today. That's really what this is about, I think. And I think it recognizes exactly what you just said, that the current system is very difficult to manage well amongst the different necessary parts to it.
Okay, there was a allegation made the last time, well, several times, I guess, about the number of times somebody has been under the influence before they're arrested on average.
On the low end, 80. On the higher end, several hundred. And it's data that occasionally NHTSA will do random stops. I mean, work with the jurisdiction to do random stops where it says, if you blow in the device, we're not going to cite you. And they try to determine, based on that, what kind of numbers come out. I've heard numbers as high as 500 and as low as 80. I've never heard any less than 80. And I dare say, let's face it, a person can go out and get well over the limit, they will probably go home. But unfortunately, relative to the entire driving population, they are much more likely to cause a wreck that causes severe injury and death. And when you go to some of the hours of the day, I mean, my goodness, what was it, just a couple weeks ago, an offender was involved with a impaired driving crash. That's at 2 in the afternoon, where she veered off into the wrong lane. So, the system does need to be improved significantly, and I think this is part of it.
Okay. Is there any information, and I think one of our other organizations will testify to this, I think there is additional information that has to do with injuries and property damage.
There are. That comes up. We tend to focus on crash deaths, but yes, there is available severe injuries, and you can extrapolate property. Very much so.
Well, any other questions for Mr. Dallas?
Thank you, Mr. Chairman, members of the committee.
There is one question over here.
Yes, sir.
Who is number 16? Mr. Setzler. Chairman Setzler.
Thank you. Could you highlight for us the impact, sort of the second order impact that's never considered? If somebody loses their license, decides to drive unlicensed, and obviously they're not going to have insurance because an insurance company doesn't cover uninsured drivers, what would the second order impact be if they're driving, say they drive drunk again, cause an accident, hurt someone else? How could you walk us through how the insurance discussion would go, how somebody who was hit by a drunk driver who's unlicensed for having lost their license but it's uninsured, could you walk us through how that would happen for a member of the public?
I mean, the first reaction that comes to mind, it's an argument for why we carry uninsured motorist coverage when you're personally a good driver. It's just as general as a lawyer, if you're violating the contract with your insurance company, driving without a license or suspended, then that coverage is just not going to apply. And so to those people involved, in general, then you're shifting the cost either to them if they can bear it through their insurance, or to their pocketbook to the extent that they can bear it. And what's the backup system? Always the state. So whether it's through the emergency room all the way through the rehabilitation, which oftentimes can be years in the making and incredibly expensive, it's a cost that we bear. And so it's not a cheap system in any sense of the word. As far as the sanctions from the state, obviously they become it could be habitual, or some of the other folks can. I've got it. Here we go. Alcohol-related crashes account for an estimated 18% of Georgia's auto insurance payments. Reducing alcohol-related crashes by 10% would save $70 million in claim payments and loss adjustment expenses. So that's a hard number that the executive director of MAD, Barry Martin, just handed to me. But it's a cost borne by us.
And I raise the question, Mr. Chairman, because there is obviously grave concern about impaired drivers causing accidents. I think there's an even graver concern of impaired drivers who are uninsured causing accidents, who, if someone's uninsured motorist coverage, which I believe is optional in Georgia, some people may not carry uninsured motorists, and if they did, oftentimes the limits are 100,000. Maybe I think it goes no higher typically than 300,000. But the members of the public that think they're covered by our laws requiring liability insurance for drivers are voided in effect if people are on the road unlicensed or driving under conditions in which their insurance coverage will not cover them. So I think the issue of people who are getting these suspensions of their license or losing their license and still are not given a mechanism to get back behind the wheel in a safe, managed environment creates a whole second order or level of exposure for our citizens that we sometimes don't think about.
I think you're right. Very well stated.
Okay, I think there was a study that I saw in the Wall Street Journal 2009 that ranked all the states in terms of the number of uninsured motorists on the road, and Georgia was pretty high in terms of 14% of the motorists were uninsured.
Right. If you're suspended, you're not getting insurance renewal.
Okay.
Thank you, Mr.
I
Chairman.
don't see any other questions. Appreciate your coming as a witness today, Mr. Dallas. Appreciate that. By means of full disclosure, Mr. Dallas is you are contracted as a
Yes.
yeah.
Yes. By way of background, I represent the Ignition Interlock Coalition for the state of Georgia in terms of they're working with many partners to change our laws based on the data and best practices from other states.
Thank you.
You're welcome.
Okay, moving along swiftly. We'll go back to the agenda. David Pratt came to me with a few weeks ago with another view of how to do handle the DUI issue, and it has to do with the 24/7 sobriety program that I believe was implemented in South Dakota. And David is here on his own because the other witness from the organization has had some physical issues and can't make it today. So we'll try to give you all the leeway we possibly can as you go through this. Go ahead.
Much appreciated, Mr. Chairman. Maybe I should go down there.
That's fine. You can sit down. Sure. You have a handout?
Mr. Chairman, I do. I've handed out the material that I
think it's
had to
here.
the committee staff.
This one, right?
Yes, sir.
Okay.
It should look like this.
Okay. Right.
Mr. Chairman, members of the committee, I'm Dave Pratt. I am with Southern Strategy Group of Georgia, and I've come here to tell you a little bit about the 24/7 sobriety program. As the chair has indicated, I am not the A team. For that, I do apologize. Mr. Bill Mickelson, who is a former Assistant Attorney General for the state of South Dakota and a 24-year law enforcement veteran, he sends his regrets, and he has committed to me, and I've committed to the chair that he will be available as soon as possible, as soon as he's able to travel to Georgia, to tell you more about the 24/7 sobriety program and to answer more technical questions. But just to give you an overview, Chairman Rice opened up with the idea that it is proper and prudent to examine what has worked in other states, and what has worked in the state of South Dakota, the Upper West, North Dakota as well, Montana, is the 24/7 sobriety program. Briefly, 24/7 can be one of a few different things or a combination of things. Most commonly it is the twice daily monitoring of an offender's blood alcohol content by way of a breathalyzer. It is also sometimes by way of measuring their drug. I'm sorry, if you'll forgive me. It is also. It can also be monitored by transdermal devices, by urinalysis, and when it is implemented, it could be used as a condition of bond. The trigger event is most commonly when an offender has been arrested for his second or greater DUI. That is when the judge's discretion can mandate that they be a participant in the 24/7 sobriety program. If I may refer you to the second page of the handout that I've given you, you'll see under the title header, 24/7 sobriety program, a graph. And this graph is a suggested correlation between the number of participants in the 24/7 sobriety program in the state of South Dakota and the decline in the number of DUI-related crashes. And moving along, if I may refer you to page 8 of the handout that I've given you. And I do apologize if I don't have enough handouts for everyone. I did try to visit with each appointed member of the committee. Those ex officios, I do apologize to you. Representative Hightower, you were otherwise occupied for a good reason. I apologize to you. But if you'll look at page 8, you'll see that a software component is also very important in tracking the progress of those participants of the 24/7 sobriety program. Why is that important? It is important because not everyone can go to the same site all the time. There are considerations on how far a participant may travel, and with the tracking mechanism, you are able to, by web-based design software, track a person no matter where they are, and you'll see there that you'll have a picture of the participant, Mr. Thomas Brown here. That way the administrator of the test will be able to know who it is that they're testing and what kind of offense, what kind of testing is required of them. I guess coincidentally, or maybe not coincidentally, there's a picture. That's not Mr. Brown, that's former Congressman Anthony Weiner. I guess when I told the guys in South Dakota that I was going to be speaking before an all-Republican committee, they sent me this one. In states where they're all Democrats, there'll probably be a picture of me. But anyway. And at the very last page of this handout that I've given you, you'll see a study conducted by Dr. Bo Kilmer. Dr. Kilmer is with the RAND Corporation. What they've done is they've conducted a study of the 24/7 sobriety program and its efficacy. The study is conducted over several years. You'll see the preliminary results of that study and hard scientific data demonstrating the results of the 24/7 sobriety program, and since it's been implemented, how dramatically it's reduced DUI recidivism in those states.
Other questions? Me? Mr. Fleming?
Thank you, Mr. Pratt. So basically, I'm somewhat of a newcomer to the details of this discussion, but basically, this program, and correct me if I'm wrong, as I understand it, you basically get tested twice a day.
Twice a day.
And this is someone who's already offended, and this is part of their rehabilitation / sentence / whatever deal they made with the court or law enforcement to be able to continue to be able to drive. You go somewhere twice a day, and you have to blow twice a day. Is that pretty much what it amounts to?
Representative Fleming, that is correct, twice a day. And it enables the offender to, if you will, get on a track to sobriety. It enables them to get tested, to be held accountable. There is a swift and sure sanction if they fail to blow clean on these sobriety tests, and that's the basic design of the program. Yes, sir.
It seems similar to the concept that my 13-year-old seems to do his chores when I'm at home more than when I'm away from home.
Nicely put,
Thank
yes,
you.
sir. And to give you an idea of where the 24/7 sobriety program is implemented right now, as I indicated, in both the Dakotas and Montana, it is on a statewide concept. And in Washington State and New Mexico, there is legislation. There is legislation pending in Arkansas and Missouri, and it is being conducted on a pilot basis in the state of Missouri, and really, really close to us, just south in Jacksonville, Florida. They are in their 30th day of their pilot program, and we anticipate in the next 60 to 90 days to be able to give the committee hard data on how successful the program has been in Jacksonville.
Representative Hightower.
One of the things that I've read here in this
Oops, sorry.
that you gave us, one thing that I like to see is, and I haven't seen it before, is that when we're dealing with alcohol-related issues such as DUI, if we can cut back on the recidivism rate, and even those that initially decide to go out and do DUI because they hear about the consequences they may face. You have here that during the study that this was done, during the years of this study between 2005 and 2010, it said you also showed a 9% reduction in domestic violence arrests.
That's correct, yes, sir.
That to me, I mean, we're dealing with a topic that's, one, definitely related to DUIs and the consequences on our roads. But if we can get people to make better choices, it looks as though it's going to have a profound impact, not only on DUIs, but also on domestic violence, according to the study you're giving us.
Yes, sir. That is indeed correct. And if I may, let me back up a couple steps. The program initially began in the state of South Dakota, and it started out as just like a little a pilot project in 5 counties. It quickly became apparent that the program was quite successful, and the judges and some DAs decided, you know what, let's expand it to some more counties. And after that, they decided, let's expand it to more crimes than just DUI. Any crime that has as its nexus an alcohol-inspired event, they decide to say, you know what, if you are convicted of domestic violence, if you want to be able to see your children, you got to prove your sobriety, and you got to be a participant of this program.
Follow? Fine. Thank you. Chairman Sassler. I do have a question about some of the means they have to collect information. I'm looking at some of the documents you have here. You've got patches, and you've got things on people's ankles that are tracking devices. And I guess my question to you is, what is these seem to be tied to sobriety specifically as opposed to sobriety behind the wheel of a car. I raise the question because I think we do have an interest as a state to ensure that when people get behind a car on state-owned roads that they're sober. I think there's maybe a broad interest, perhaps, to desire sobriety, but I'm trying to understand the philosophy behind, if someone's not getting behind the wheel of a car, where do we draw the line in ensuring someone is just per se sober, sitting at home, not being drunk or not consuming alcohol? Are we getting into a territory where we're just, as a state, mandating or monitoring people's general sobriety as opposed to sobriety behind the wheel of a car? Because sobriety behind the wheel of a car on a public road is a very different thing. And it just raises some concerns. I certainly can see some advantages to people being less drunk across culture, but where is our mandate as a state in maintaining general sobriety not tied to driving an automobile?
That's a fair question, Representative Sessler. And I suppose I would suggest to you that in particular to the instances that I've provided in the Dakotas and Montana, it would be up to the individual legislature, it would be up to y'all to decide what line should be examined. And the states where it is a program, where the program is in effect, they've decided that if someone has 2 or more DUIs, they have a problem with alcohol. And if you have two or more DUIs, then you've demonstrated that you have less than an ideal regard for human life if you're willing to get behind the wheel. Given that, the legislatures of those states found it prudent to monitor your alcohol level, no matter what. But again, sir, that would certainly be up to the state of Georgia and y'all's pleasure as a General Assembly.
Okay, Chairman Powell.
If I could just address that last question, I think that a general condition of probation in just about every court is that you will not consume alcoholic beverages or frequent places that sell for on-premise consumption alcoholic beverages. So we require that now. We've just got no mechanism to police it. So if you put somebody on probation for DUI for a period of 12 months, that's generally going to be a condition of probation anyway. Now we can just monitor it. So we're not intruding any more than what we're legally authorized to do already.
I agree with that, Chairman.
That was my comment as well.
You pass.
Thank you. We appreciate you coming today, David. Just filling in. You did a good job of of maneuvering through this, and you represented your client very well. And I appreciate you coming. I think this is a something we ought to consider. And by the way, I think these are. You mentioned Washington State. Washington State just implemented a very aggressive interlock device program too. And so apparently they work together. Is that right, or do they work in opposition to each other?
Well, that is entirely dependent upon what jurisdiction you talk to. In some instances, they can work in concert with one another, and other instances, some jurisdictions have chosen one over the other. It has been demonstrated that 24/7 sobriety program is an effective tool in reducing recidivism, and whether or not you choose one or the other or both, completely up to you.
Chairman Powell.
Just, I guess one is a question and one might be a comment. One of the concerns for anything that we do, we want to make sure it's going to work everywhere in the state, not just in the metro areas. And one of the concerns that I have in the rural part of the state of Georgia is that certainly with an interlock device, they can take their car, get it fitted with the interlock device, and probably somewhere within 30 to 50 miles of just about every community in the state of Georgia. And then as long as they are under the supervision of the court, then it's not like they've got to go someplace. And what about this twice-a-day reporting for people who don't have public transportation? How's that going to work as far as, or is there a remote monitoring? I see one of these things looks like it does a remote monitoring like an ankle bracelet type thing. So are those part of the program so that in rural areas without public transportation that you still can have the same kind of program and the same kind of effectiveness?
Without a doubt, Chairman. As you can imagine, you live in a rural part of the state. I visited with you yesterday. As you can imagine, some parts of the Dakotas and Montana, there's a lot of stretch between municipalities and where someone may live. That's why one of the methods that they've employed in monitoring the blood alcohol content has been transdermal devices or ankle bracelets, that kind of thing. So, your concern over someone not being able to get to a point to a testing facility is very well taken, and that's why they use ankle bracelets in some instances. Now, if someone is using the 24/7 sobriety program as a condition of license or reinstatement, then it would necessarily follow that they have transportation at their disposal. In the instances where it may be imposed as a penalty of domestic violence, for example, and they just don't have the transportation or the means to get to a testing site, again, that's where the ankle bracelets and those kinds of devices are being employed.
Okay. Then my second question, I guess, is dealing with recidivism, and we discussed this when you came and visited with me, is one of the things that we learned in the criminal justice reform was that recidivism, we have been throwing the book at people, we've been doing all sorts of things, and it hasn't really changed recidivism, but it has gotten people off the street, but once they get back out, they reoffend within 3 years. And certainly your data, your crash data is interesting, but I'm also interested in recidivism and whether you can get us some data as far as whether this actually cuts the recidivism rate.
Mr. Chairman, you did ask me that question. I apologize I did not answer it or address it earlier. But yes, the chairman did have a question as to while someone's under the 24/7 sobriety program, be it 30 days, 60, 90 days, yeah, their rate of recidivism is going to reduce. The chairman asked me, okay, what about 3 years, 5 years down the road? And that, Mr. Chairman, that has been studied in the RAND Corporation preliminary test results that I gave you. It indeed does indicate that recidivism is reduced over a 3 to 5 year period of time. Yes, sir.
Okay, thank you.
We're running behind schedule, and if you could keep our questions and comments to a shortest net format, that would be great. That's not directed at you, Chairman Setzler, but you're the next one to ask a question. No? He passes. Wow. It worked. Okay. Well, David, thanks for coming today and representing your client. We appreciate it. And we'll see you at another time.
Chairman, members of the committee, I do thank you very, very much. And as I have committed to the chairman, we will get back here with our aid team most promptly. Thank you so much, everyone.
Next up, from the standpoint of testimony, is a lady who knows from what she speaks. Her name is Ann Teagan. She's from NCSL, and she did the presentation at the recent NCSL meeting on the Washington State implementation of interlock. We want to come on and say hello to us here. Are you going to stand up there and do it, Ms. Teagan?
Is the microphone? Okay.
It's on.
All right. Thank you, Mr. Chairman. My name is Ann Teagan, and I am a program principal at the National Conference of State Legislatures. And just a quick overview, NCSL is a nonprofit bipartisan organization, and among our goals is to provide legislatures with information and research about policy issues, both state and federal. And I work on and I track traffic safety issues, including impaired driving and drug driving. So.
You're going to direct us to the screen up here?
Yeah, there's just one map that you'll want to look at one point. So I'm here to discuss trends and recent enactments related to ignition interlock laws. And as we know, the alcohol interlock is a breath testing unit that a driver must blow into before starting the vehicle. If it exceeds a preset level, the vehicle won't start. As noted by ignition interlock researcher Dr. Richard Roth, there are about 1.4 million DUI arrests a year, and about 320,000 interlocks are installed each year. So that means only about 15 to 20% of offenders arrested for DUI actually install the interlocks. But research has shown that when they are installed, they reduce the rate of rearrest. A 2011 review of literature by the GAO assessed the effectiveness of ignition interlocks, and they identified 15 studies that observed that ignition interlock installation reduced the risks of being rearrested for DUI offenders compared to DUI offenders that were not using the devices. To give you some history, before I go into the state trends, I really must mention that significant changes to federal law in 2012 did allow the states to pass ignition interlock laws with more flexibility. Since 1998, federal law had required that certain federal highway funding be withheld from states that do not require a hard suspension of a driver's license of a repeat drunk driving offender. States that did not enact such laws were forced to divert their highway and infrastructure spending to traffic safety programs. Now, as mentioned by Mr. Dallas, research has shown that hard driver's license suspensions and revocations are not an effective deterrent or punishment for drunk driving. Many impaired drivers whose licenses were revoked continue to drive anyway, illegally, to work, children's school, and generally around town because the risk of getting caught is not that great. The enactment of MAP 21 in 2012 gave states, without losing federal highway funds, the flexibility to pass laws that allow immediate interlock installation without the 45-day mandatory license suspension. MAP 21 also allows states to decide which locations the repeat offender can drive. Previous law had restrictions where they could only drive to work. Now those restrictions are gone, so they can drive, say, to treatment or somewhere else. MAP 21 also offered grants to states who enforced ignition interlock law for all offenders. These grants have come under some criticism because the bill was so stringent, almost no states qualified for the grant money. In all, 14 states have applied for the ignition interlock grants created by the 2012 transportation law, MAP 21. only 2 states, Connecticut and New Mexico, qualified for the funding in the first year, and Arizona and Washington did qualify for the funding in fiscal year 2014. There has been a lot of talk in Washington about proposals to loosen the eligibility rules in the next transportation reauthorization. So state houses around the country have been enacting and amending ignition interlock legislation at a rapid pace over the past 10 years. By 2011, all 50 states have had some ignition interlock law. And New Mexico became the first state to require ignition interlock devices for all convicted drunk drivers, including first-time offenders. Now, 21 states require these for all offenses. Colorado and Maine provide strong incentives for the first offender installation, and California currently has a pilot program that includes Los Angeles County that requires all convicted drunk drivers to install devices. A few themes that I'm going to present on is what I'm seeing in ignition interlock legislation is that it's being expanded to more offenders, and the offenders are allowed to install the devices sooner with little or no hard suspension. Colorado amended its license suspension time from 1 year to 1 month if the offender applies for ignition interlock restricted license. Similarly, Maine now allows a first offender's license to be reinstated after a 30-day suspension. A 2014 Florida law now allows judges to order interlocks for first-time offenders with a BAC of 0.08 to 0.14 in lieu of a 10-day vehicle impoundment that they had required. This year, Maryland changed its provisions for repeat offenders as well, and the new law gives the offender a choice to either submit to a full license suspension for 1 year or immediately install an ignition interlock device and participate in the ignition interlock program for 1 year. I just wanted to note that Maryland Senate Bill 87 also repealed the provision that allowed the Division of Motor Vehicles to exempt employer-owned vehicles from the interlock requirement. That's only important because most of the states that applied for the MAP 21 grants that I mentioned were disqualified, at least in part, because of the employer exemption provisions. So another theme that I'm seeing, and here's the map. Here are the states in light blue that require at least some offenders to install interlock devices that are equipped with a camera. The camera captures the image to ensure the right person is actually utilizing the device to start the vehicle. And Oregon did pass a law this year, but the requirement doesn't go into effect until June 2015. And another trend I'm seeing is the legislatures are designating a fund for program administration and for indigent offenders. In West Virginia, offenders must pay a $100 application fee that goes directly into the driver's rehabilitation fund, and that fund is designated only for the costs associated with program administration and for indigent offenders who cannot pay the associated fees for installing and maintaining a device. In 2014, Mississippi just formed an interlock device fund that requires all offenders installing to pay a $50 fee, and then after offenders have gone all the way through the program and are ready to reapply for full licensure, $25 out of the $100 reinstatement fee goes back into that interlock fund as well. A more recent theme that I'm seeing is ignition interlock legislation, a statutory requirement for compliance-based removal. Compliance-based removal means that an offender must use the interlock device and not fail any of the tests for a certain amount of time. New Hampshire just passed provisions requiring an offender to have a record of 120 days with no reported fails on the interlock. Vermont's law, which was also just recently passed, will add 3 additional months to the offender's ignition interlock requirement if the offender makes 3 attempts to start the vehicle with a BAC of 0.04 or above. I know there's a lot of references to Washington, and I am going to take a few minutes to discuss the ignition interlock program in the state of Washington. And I'm using it as an example because they have integrated many of the provisions that I just mentioned, and there has been some research on how the program is reducing drunk driving. As you can see, it really has evolved over time. In 1987, the ignition interlocks became available in the state of Washington. One important thing to note, in 2009, drivers were allowed to drive during their suspension as long as they had an interlock installed. The interlock in lieu of suspension option was available immediately. In 2011, the legislature passed compliance-based removal provisions, which required 4 months of driving with an interlock device where none of the following occurred. No attempt to start the engine with a BAC of 0.04 or higher, no failure to take or pass a retest, and no failure to appear at an ignition interlock vendor for recalibration. In 2013, the legislature amended its law to require devices to have a camera. So in 2008, Washington created the ignition interlock device revolving account to pay for the costs of administering the program and provide financial assistance for the interlock devices for persons who show that they are indigent. The account funds one position at the Department of Licensing to administer the program, and the rest goes to pay for indigent users. The revolving account is funded by a $20 monthly fee paid by persons who are required to install the devices. Now, as you can see from your handout and on the screen here, the bottom two numbers do not add up, and there is about a $45,000 gap. I spoke with a representative from the state of Washington, and they said that this is the first year that this has happened to the account, and they note that it has actually become a problem because more people are installing the device for longer periods of time, which was actually their desired outcome. So the Washington legislature will consider how to change the equation and equalize the numbers for in the 2015 session. As I said previously, Washington passed a law making ignition interlocks devices available to all offenders, including first-time offenders. In 2012, the Insurance Institute for Highway Safety studied the driver records of people with impaired driving convictions in Washington to see if that had had any effect. They found that after the state expanded its interlock requirement to everyone convicted of DUI, the recidivism rate for people affected by the expansion fell 12%. Also, after the law was passed, more offenders actually went through with the installations of the interlocks. Among DUI offenders, about 33% got the devices installed, compared to the less than 5% before the law was enacted. If all offenders had gotten the devices installed, the recidivism rate would have shown that it would have fallen a little bit more than 12%. So Washington State actually passed legislation in 2009 and in 2011 aimed at increasing installation. They changed the law again so people with DUI convictions now cannot simply wait out the ignition interlock period with a suspension. If they ever want to regain their license, they have to first drive with an interlock. And here are some other results that have been reported by the Washington Traffic Safety Commission. The chart is looking at alcohol-related fatalities. It shows that since 2009, Washington's alcohol-impaired driving fatalities have dropped 44%. The year 2009 was chosen because that was the year the state formed an impaired driving legislative working group to study the effective strategies to reduce impaired driving. Washington traffic fatalities also dropped 11% during that time as well. So those are traffic fatalities as a whole. I thought I'd conclude my talk about Washington State with this educational announcement from the Washington State Patrol. Every time Washington has amended their law, there's been quite a bit of public outreach to educate the public on what the new laws require. And just to end my presentation, I wanted to say that many legislatures across the country are considering amending their impaired driving laws to include various ignition interlock provisions that I spoke about. They're also looking at 24/7. I know Washington actually just did pass the 24/7 bill that they were considering. I believe Idaho is also considering a bill. And I wanted to point out that there are a number of organizations that have a wide range of information on the subject. First, the National Highway Traffic Safety Administration did publish some guidelines in November of 2013 that outlined model programs. And the Association of Ignition Interlock Program Administrators has a lot of information. They are extremely knowledgeable about the minutia of running an ignition interlock program. So, here is my contact information, and I'm happy to help anyone find more information on the subject.
Well, thank you for the presentation, Ms. Teen. It's been a broadening experience in terms of learning a little bit more about what's going on across the states in this area. Are there any questions for Ms. Teagan? If not, we thank you for coming down here today, and you'll be around, obviously, here for a while if anybody does have a question. Barry Martin of MAD is our next presenter. And Barry, if oh, I'm sorry, I didn't see it. I'm sorry. Stay up there for a second, Ann.
I wasn't sure you were sincere in your desire to entertain questions, but I'll
Well, there's a pecking order here.
I did want to ask a question that highlighted, I think, an important point: the non-compliance with actually getting interlock devices on. There are states that have folks are ordered to put them on, and there's just non-compliance. Folks just don't get it done. What was the kind of turning point for Washington that made it really happen, and what percentage did they get to as a result of that? Because I know in Georgia, our conditions are a little bit different, but there's still states where there's vast non-compliance with actually getting a device put on.
Well, like I said, the Insurance Institute for Highway Safety Study did show that they went from 5% installing to 33%, which is a pretty significant jump, and 33% is more than the average of 20% installation. So I wouldn't venture to guess why people get it installed and why they don't, but I would say, from a standpoint of, I was in a meeting a few years ago, it was maybe 2009, and they were very frustrated with the fact that their hands were tied due to the federal law that required a hard suspension. They believed that getting the ignition interlock on sooner and just making that an automatic thing would be better in the long run, because then people wouldn't be used to driving illegally, and they would just have it on as soon as they lost their license. Whereas if you drive for 45 days with a license suspension, and you're like, well, I haven't been caught, I haven't really been doing anything, maybe I won't install an interlock, I should just chance it, I think one of the other reasons, I do have somewhere, NHTSA gave a variety of reasons that there's a low rate in installing, but a lot of it is it takes a lot of money to monitor, to ensure the offender has complied, and so that goes back to the ignition interlock program. If you have some monitoring of that, also some people just can't afford the fees and the cost, but with the indigent fund, that kind of is taken care of as well.
Okay. And I just raised a question, Mr. Chairman, because if it's an option, then people choose themselves freely whether they do it or not. If it's ordered, I think we as a state need to make sure that if something's ordered to be so, then there be an airtight system to make sure that it's so. I've seen places, I've heard of states where it is ordered and it still doesn't happen, and I just can't imagine. We don't have a high percentage of folks who are ordered to show up for court and then just don't show up for court and nothing happens to them. They're just sort of allowed to linger. that doesn't happen because our judicial system has the records are pretty airtight in making sure that things follow through. So whatever we do, we need to make sure we administratively do it well, and don't have what we have in other states. So.
Thank you, Ann, for coming. We appreciate your spending the time and resources to come down here today and educate us a little bit more. Barry Martin is our next witness, who will be Barry's the Executive Director of Mothers Against Drunk Driving. And Barry, why don't you speak to us about what's on your mind this day?
Yeah. Thank you, Mr. Chair. Thank you, committee, for having us here today. MAD supports legislation that will require ignition interlocks for all convicted drunk drivers. That's first time, .08 and above. Similar legislation has passed in 25 states, and the results have been tremendous. Ignition interlocks are one of the most effective measures available in stopping drunk driving. In 1980, drunk driving deaths were approximately 22,000 fatalities per year, and about 570 here in Georgia. Since then, we have had a lot of success in reducing those numbers. Of course, we're down around 10,000, less than half of what it was in 1980 nationwide, and we're down to about 301 in Georgia. I would just like to highlight that Mr. Dallas mentioned a 7-year span here in Georgia where we've reduced traffic fatalities, roadway fatalities, continuously for 7 years. There is one blip in the radar, though, that I want to bring to your attention. For the first 6 years of those, drunk driving fatalities also fell along with the regular traffic fatalities. That's not true anymore. In 2012, the number actually went up. So despite even having a drop in the overall traffic fatalities in 2012, we saw an increase in the fatalities due to DUI. That means, of course, that there is a higher percentage of the roadway fatalities in Georgia are DUI related. So my point there is that the fight is not over. The fight has not even begun. We still have someone being killed every 53 minutes in America. We have someone being injured every 90 seconds. Ms. Teagan talked about the trends. Let me give you one trend. In 2006, there was only one state in the union that had an all-offender ignition interlock law. By 2010, that number had risen to 17. That's 4 years into the process. 4 years later, now in 2014, all 50 states have some form of ignition interlock laws. 39 states have some form of first offender interlock laws. That's 25 all offender, .08 and above for all offenses. And 14 have high BAC ignition interlock laws. In the last year alone, we've had 2 more states come on with all offender, and 3 states moved from high BAC over to all offender. If you look on page 5 of my handout, you'll see a nice list of all of those, the status of all of those laws in each of the states. It's interesting to note as well that all 5 of our border states have some form of first offender interlocks. It's also interesting to note that in 2006, when MAD started waving the banner for ignition interlock, we were pretty much alone out there. Now, the U.S. Department of Transportation, the National Transportation Safety Board, the National Highway Transportation Safety Administration, the Governor's Highway Safety Association, AAA, the Insurance Institutes for Highway Safety, the Association of Chiefs of Police, and many more highway safety organizations out there have gotten on board to recommend all states require ignition interlocks for all convicted drunk drivers. In Georgia, ignition interlocks are required for only repeat offenders. We need to strengthen our current laws by requiring these devices for all first-time convicted drunk drivers. We know that ignition interlock devices are a practical and proven way to stop drunk driving. Conversely, we also know that as many as 75% of convicted drunk drivers will continue to drive on a suspended license. 15 peer-reviewed studies, including those from the Centers for Disease Control, prove that ignition interlocks work by reducing repeat offenses by 67%. That's compared to offenders who only had their license suspended with no interlock order. Highly incentivizing or requiring the use of ignition interlocks for all convicted drunk drivers will help prevent repeat offenses and in so doing save lives. Ignition interlocks in other states have helped decrease drunk driving fatalities by as much as 44% in Washington State, 43% in Arizona, 42% in Oregon, 35% in Louisiana, 38% in New Mexico. When in your handout, there's some research on economic data from the Pacific Institute of Research Evaluation. When they did their initial studies back in 2005, before any ignition interlocks were out, they anticipated an 8% drop in drunk driving fatalities. 8% is what was anticipated. And we're looking at even the most modest results in the state of Illinois are 22%, and we're as high as 44% in Washington State. That means that 2,700 lives have been saved nationwide as a result of ignition interlocks. We know that if we get similar results, just 22%, we can save 66 lives in the state of Georgia. That's 66 lives the first year, 66 lives the second year, and on and on and on. If we get the results that Washington State has, we can save as many as 138 lives each and every year, year after year after year. We know that these results, similar results in Georgia, would reduce the number of injuries caused by a DUI by 2,000 to 6,000 people every year who will not be injured because of DUIs. Of course, saving lives is our cause. That's what we're here to do. But I want to also bring to your attention some economic issues that are at play. As I mentioned, alcohol was a factor in 25% of the vehicle crash fatalities in 2012 here in Georgia. Alcohol-related crashes are deadlier and more serious than other crashes. Alcohol-related crashes in Georgia cost the public an estimated $4.4 billion in 2005, the last data we could find on that. That includes $1.8 billion in monetary costs and almost $2.6 billion in quality of life issues. Again, that's according to the Pacific Institute of Research Evaluation. People other than the drinking driver paid $2.8 billion of that alcohol-related crash bill. The average alcohol-related fatality in Georgia cost $4.9 million. The estimated cost per injured survivor of an alcohol-related crash averaged $145,000. So, Mr. Chairman, to conclude, I urge this committee to recommend all offender interlock law become the law of the land in Georgia. We know that 25 states have passed similar interlock laws, 14 others with high BAC interlock laws. And since 75% of convicted drunk drivers will continue to drive while suspended, it's time for a new approach. This legislation is proven in both in other states and in independent research to save lives. It's the right approach to the crime of drunk driving and will teach convicted drunk drivers to drive sober and to help protect the public. Thank you.
Thank you, Mr. Martin. Representative Quick, you have a question?
Thank you, Mr. Chairman. What is the cost, the monthly cost of the interlock?
I believe it's somewhere in the order of $2.50 a day. I believe Jack Dalton from the Ignition Interlock Device Coalition will address that further, but my understanding it's around $2.50.
Thank you.
Any other questions for Mr. Martin? Okay. Chairman Powell.
I noticed in one of the handouts that one of the states, I think, requires the interlock device not only for a DUI conviction, but also on a reckless driving conviction if the underlying offense was a DUI that's been knocked down to reckless driving. Do you have a feel for that as to whether that would be something that we would also want to consider in the state of Georgia if there is a lot of plea bargaining, so to speak, down to reckless driving?
Yeah, I think Mr. Dallas was questioned heavily on the number of DUIs that are plea bargained away and end up something else. I think, anecdotally speaking, I don't obviously have good data on the number of cases that are reduced, but I can tell you from experience that we've seen when we do the audits in various courts, you get everything from a DUI coming down to reckless driving, but believe it or not, there are courts out there that will reduce it to disorderly conduct. A non-moving violation has nothing to do with even being in your vehicle, and that's not an isolated incident. There's a court outside of Valdosta that had 200 DUIs and DUI arrests in the year 2012 and only one conviction for DUI. And so, as far as I'm concerned, anything that starts as a DUI, you can put an ignition interlock, and I'll be quite happy about that.
Thank you.
Any other questions for Mr. Martin? Thanks. None? Okay. Thanks an awful lot, Barry, for coming in today. We appreciate it. And The next witness will be Jack Dalton. Jack's representing Lifesaver Interlock. And Jack, welcome. Thank you for appearing.
Thank you, Mr. Chairman, committee. I'm Jack Dalton. I am the Director of Public Policy for Lifesaver Interlock as well as for the Coalition of Ignition Interlock Manufacturers. I've been doing this for 25 years, and I want to tell you this has been one of the best. This year, we got Delaware. I've been working on Delaware. I got the first bill passed in Delaware in 1991, and this year Delaware became the 24th state to mandate ignition interlocks for all offenders, and a fantastic program there. Maine came on this year. West Virginia, where I worked very hard, also strengthened their bill this year. Alabama went back and made changes. All across the country, it's happening. We finally found a way of reducing those alcohol-related deaths, reducing the crashes in a way that we've never had before. Before, we have always treated the offender as a criminal. Or, worse than that, he just made a mistake. And that's the big problem we had, just made a mistake. Talking about reducing the charges down to reckless driving. Joe just made a mistake, we'll give him a break. What we missed was, we had an opportunity to change that person's life. We had an opportunity to teach that person something. And what did we do? We slapped his hand, don't do that again. Don't do that again. And when they got to the fourth and the fifth DUI, we came back and said, what happened? What can we do to stop this carnage? I got invited to a TV show one time. How are we going to stop this guy? He's killed 3 people now. This is his 5th DUI. And I finally said right on television, we can't stop him now. You let him go too long. You've got to stop them at the first time. You've got to help them. You've got to have them the opportunity to show that there is a behavior modification. Here's what you've been doing. Here's what you need to change it. And look what's going to change when it does. Now, we've had it happen across the country. I'm so happy that Ann was here with the results from the Washington program. I will remind you that you are in a mix of states across the country. It's your job to come up with the program that's best for Georgia. Washington has done it. I sat with the folks in South Carolina who did the same thing that you're doing. They brought in all of the stakeholders and said, what do we need to do? And this year they passed a fantastic law in South Carolina. I will give you one caveat, though. The defense attorneys came to the table and said, oh, we don't want it for .08, we want it for .1. And that's where it came out. But after it was passed and the cameras came out, all of them came out and said, yes, we supported this. So make sure you get it right, because there are a number of states who have done it already, and they show what the figures are. Number one, I want to address the situation as far as a 24/7 program is concerned. There are a lot of programs that work for DUI. As the gentleman said, this is primarily for second and subsequent offenders, and that's where the states are using them. Washington is now going to use a 24/7 program. The ignition interlock is a very important part of that as well. But most important is that we have the ignition interlock on the car of the offender as soon after arrest as possible. Now, I want to go back to one of the charts that Ann had up there and talk to you about how important what you're doing is. And this is a chart that you should have in your packet. And it shows that 11% decrease in the number of deaths, and then a 44% decrease in the number of alcohol-related deaths over the same period of time. And I'll refer you back to Barry Martin when he was giving the numbers for the number of people in Georgia that can be saved. Imagine what you can do in saving lives and saving cost to members of or citizens of Georgia by reaching these same numbers here. And what you have is you have all the organizations across the country. I had them in my notes. Barry mentioned them all out with CDC, with the Governor's Highway Safety, with the Insurance Institute for Highway Safety. It's been a wonderful thing for me. Up until 6 or 7 years ago, I was out there by myself. And all of a sudden, these studies started coming out, and people started finding out how effective it was. And first, in I think it was 2006, MAD came out and supported ignition interlock. I said, oh my gosh, look what's happening. and then the CDC, and then the National Transportation Safety Board, the Insurance Institute for Highway Safety. They're all saying the same thing. What we can do for highway safety is get that person on the ignition interlock as soon after that event as possible. It teaches them, and it protects us. And that's exactly where we want to be. We've had some situations across the country. As I say, we're in a trial area where all the states are developing their own programs. They've learned some things that we want to pay attention to. First offenders are not people who just made a mistake. They're someone who needs to be treated, someone who needs help. Offenders will sit out the suspension. One of the things you have to consider is making sure that they know going in that they will not have a fully unrestricted license issued to them until the ignition interlock component has been completed, because they would prefer to sit that out rather than have the device in their car. We're not installing the devices. There was a question earlier about why did the number go up in the installations in Washington State. One of the reasons that they went up in Washington State is Washington State has 5 troopers who are authorized to go out and knock on doors and say, show me your car and show me your interlock. If not, you're coming down to jail. That's one of the things that they did. In South Carolina says if you don't install the ignition interlock and you're found to have not installed the ignition interlock, there's first a $500 fine, then a $1,000 fine, a $1,500 fine, and it goes from a misdemeanor right on up to a felony. They do the same thing if you're caught driving a car without an ignition interlock in it. So these are things that you're going to want to look at to make sure that you do have the compliance. Washington State has the best compliance of any in the country, and that's a little over 50%. And as Mr. Setzler said, a lot of them don't have that same penetration because they haven't paid attention to it. Another thing that's important is diversion programs across the states. West Virginia is one of those. Delaware is one of those. South Carolina is one of those, to where they offer that first-time offender the opportunity, number one, let's straighten out the problem. Number one, let's get the ignition unlock on your car right away. Then, if you complete the program successfully, we'll give you the opportunity. West Virginia likes to use the term hide the conviction. Conviction doesn't go away. The conviction is still there. If you have a second conviction, then it applies as a second conviction. But someone in school, someone looking to start their career, they don't have this on their record if someone checks the record. So that's something that you'll need to work with your legal people, your lawyers with, to work out. But that's something that's very important. That gives those young people a chance to hide it and make sure that they don't let that happen again. So that's also important for you. Programs have been developed as far as the monitoring is concerned on the device. One of the things that we have, and the representative asked a question about what the cost of the device is. And yes, for the basic device, it's about $2.50 a month. With, if you add the camera, I'm sorry, a day, $2.50 a day. If you add the camera, there is also a technology called GPS that some states are starting to use now, because if they have an arrest, they want to be able to prove where it happened, and that might bring it up to around $3 a day if you add those things. But it's less than the cost of a beer. We need to monitor the people on the program to make sure that they're doing what they do. The cost of that is borne by the offender, but there's also a cost to the administration. So one of the things that you want to work out, and we heard Bob Dallas talk about that earlier, as far as covering the cost for the administration of the program is concerned. One of the ways that states have done that to reduce that cost, in the past, take Delaware for instance, Delaware passed a law and they said, okay, if you have a violation of the devices, and they read them off, if you miss a running retest, if you fail at .04, if you don't show up for your appointment, and they were keeping track of those, and they would give you points for each of those violations, and those points would add up to an extension of your program. That proved to be very expensive for the jurisdiction. So what Washington did is Washington came out and said simply, you must have 4 months of violation-free service, or you don't get off the program. There's no extension of the program. The program runs until you have had 4 months of violation-free service. So what that does is that takes away the work that DDS, the motor vehicle, has to do to monitor the clients. So overall, I'm sorry, another thing I want to mention is the camera devices. Camera devices are available that identify who is in the car and who is blowing the test for the ignition interlock. So that's important as well. And I think I've covered everything. Any questions?
Yeah, you do have some questions, Mr. Dalton. I think the first one was from Chairman Powell.
Yes, sir.
Mr. Chairman. Thank you, sir. I was interested in your saying that the earlier we can get the interlock device on a vehicle, then the better off the offender is, as well as the better off the rest of us are. And my question is, just like in, say, domestic violence cases, we can have a condition of bond, somebody getting out of jail after they've been arrested, that they stay away from the spouse or whomever it may be. Are there any states that routinely are doing as a condition of bond in a DUI that an interlock device may be installed on the vehicle?
Texas is doing that right now, and I'll apologize, I don't remember, but I just heard 2 or 3 days ago about another state that's doing the same thing. So I will find out for you about that, but Texas was the first one to use it as a release for bond.
Is there any data that's indicating whether this is reducing fatalities, reducing recidivism? I know that, like in accountability courts, you know, the sooner the I hate to say punishment, but the sooner that there are consequences for behavior, the more effective it is on changing behavior. And so it would seem, if that is a good rule of thumb, that certainly the sooner that we get the interlock devices on and change people's behavior in the time constraints of when they misbehaved. And so I was wondering if there's any kind of evidence out of Texas that maybe that has reduced it more than what Washington's doing.
I don't know that. Again, that is for bail bond. I'll have to check on that and find out what the results of that has been. What I will go back to is all of the research that are saying exactly what you're asking right now, is that yes, we are better. It's not me saying it. It's these people saying it, that we are better off, we are better protected, and the person is better served if that ignition lock is on there as soon after the event as possible. We heard someone talk about Hightower, your area, where it's very rural. How are people going to get to where they have to go? How long can they go without their car? They're not going to go without their car. They do not go without their car. They go back out and get in a car and they drive. And Representative Sessler said the same thing. We need to keep them from driving the car. We're not worried about whether they're sitting home drinking a beer and watching television. We need to make sure that they're not driving a car while they're impaired.
Okay. Thank you.
Representative Hightower's question.
Chairman Powell and I are on the same page on a lot of our questions today. That's where my ears kind of perked up when you said get it as soon as possible, because typically here in Georgia, the interlock device comes as a condition of a sentence, and sentencing comes way down the road typically. I mean, most courts, depending on the court's backlog and what they have, I mean, sentencing can be anywhere from 4 to 6 to 8 months or longer down the road. What in other states outside of Texas, what are they doing? What are procedures or policies they have in place that allow them to do this sooner? Like Texas, they do it as a condition of bond. What are other states doing to get this done sooner?
Well, one of the things, if you look at the bill that was just passed in Delaware, is Delaware says to the person, well, you're not convicted, but if you have the device put on right away, we get your license back to you right away, and any time that you spend on the ignition interlock during this time before your court date will be credited to you on a day-for-day basis, so that anytime you're on a program ahead of time, you could have that credited to you. So that also incentivizes people to get on the program immediately. They don't have to wait for the conviction, And I'm sure you've heard the stories of the guy who had an arrest, and before he's convicted, he's had another arrest because he went out and started driving again. So give them the opportunity. And that also plays into, and again, you're going to have to work with your legal people to work it out. But that also solves the problem of the ALS. It solves the problem of the police departments, because now they can say, okay, if you want your license back now, you're not going to have to go through the suspension. You're not going to have to go through all of this. You can get your license back now, but you'll waive the hearing. And that's what.
That was my next question. In that scenario, it seems as though that would take out the ALS process, so to speak.
And we can get you information on states who actually are doing that. It's already been written in the code.
And I guess they're put on notice, like through law enforcement at the time of their arrest, that's an option. Is that how they're placed on notice to do that? Now, does that also, do you see that impact on other states where people refuse to take tests? Because like I said, when we first started this, that was one of our major concerns. We want to find a way to be more aggressive on those that refuse. Does this help in that scenario as well? Those that refuse, that they go ahead and they start getting this interlock device in their vehicle?
I would point you towards South Carolina and Connecticut, who have done exactly that with refusals.
With refusals?
Yes, sir.
Okay. And again, that would also tie back into the ALS scenario that we're having here, and it would kind of, the way that I see it, the way that you're explaining it, would seem to take a little bit of a burden off law enforcement.
Yes, it does.
And then that goes to the argument they made, I can't remember who made earlier, said that some law enforcement, do you feel as though law enforcement's not writing some of these tickets because of the protocol they're having to go through and they're having to go to these hearings that they may have to testify at? If we take that burden off of them by still finding a way to be more aggressive with the DUI sentencing, it seems like that would be a route we would need to try to at least look at or explore. So you're saying this is working in other states in that way?
Oh, absolutely. And the data is there. There's no more having to prove it. It's working it into your code, how it works best for Georgia, and that's your job.
Well, I look forward to seeing how law enforcement would take that too, because I'm very curious what their input would be on not having to do ALS hearings. I think we're going to hear from Captain Mark here in a little bit, and so hopefully he can give us some insight on what law enforcement's take may be on if that were an option, how they would feel.
Chairman Setzler. Oh, well, I guess I missed up here. Representative Quick, is that you?
Yes, sir, Mr.
I'm
Chairman.
sorry.
Thank you. I'm sorry, was it Mr. Dalton?
I'm just so used to calling on this. If you want to formulate one, I'll
I'm still trying to drill down on the cost of the device and the cost of the installation.
Okay.
And I'm not a criminal defense lawyer, and I don't handle DUI cases. So what I have found here, trying to do a little research, is a National Highway Transportation and Safety Administration report and sort of a comparison between states from 2012. And so that's what I'm looking at. But I'm trying to figure out if the estimate that you have given is the cost of everything that might include what's listed here is program enrollment fee, device installation fee, device monitoring fee, device transfer to new vehicle fee, device reset fee, device removal fee, missed appointment fee, program reinstatement fee, roadside service call fee. What are all the components of the charges associated with the device is what I'm trying to educate myself on.
Okay. Number one, let's take the very simplest situation. The person comes in and have the device installed. This is a competitive market. There are, I believe, 8 vendors in in Georgia who are providing the program. Normally, the installation fee will be $75 to $125, depending on the complexity of the vehicle. There are normally fees involved for removing that device from the car, which again will run between average of $50 to $75. Because this is a competitive business, you'll find that if you call a ignition interlock provider and say, what is your cost for installation, and call the guy down the street and would say, well, we're giving a free installation this month. That's one of the reasons that the price of the device itself, the monthly fee, has stayed consistent around that $75 to $80 range for the last 10 years, because the business is getting more competitive and people compete with each other. So the person goes in, they get ordered onto the program, they go to the vendor, they choose the vendor that they want to use. Either that vendor has a $50 to $125 installation fee, or the guy down the street is giving them a deal and they don't have to pay that. So they go in, they have the device installed in their vehicle. Once it's installed in their vehicle, they're given an appointment, and I don't know if the monitoring in Georgia is 30 days or 60 days. But when they come in, they pay for that next period up front. So if it's a 60-day monitoring period, they'll pay, $75, they'll pay $150, and that will cover them for the next 2 months. That is their download fee, that is their monitor fee, that is their lease fee, that is all those things that are normally included in the program. Now, if that person goes out and that person blows violations into the device or tampers with the device to where they get called back in to the service center for violation of the program, then there can be a device reset fee, there can be a penalty fee that's included onto that.
Thank you.
And what were the other charges? Were there a couple other charges I missed on there?
Missed appointment fee.
That's the same thing. If you show up, if you make an appointment with a vendor, if you don't cancel within 24 hours and let them know, they'll charge you a fee for missing that appointment.
Roadside service call fee.
There are some people who don't want to bring their vehicle in, and they'll pay someone to go out and service it for them at their house.
And transfer to a new vehicle if somebody.
That's the same thing. If you want to take it out of one car and put it into another car, then the installation, if we're going to have to take it out of here, that's a $50 and put it into here, $150. They'll normally, again, it's competitive, they'll put it together and charge a lower price for the complete switch. But for someone who is doing what they're supposed to do, not blowing violations into the device, then their cost is going to be $2.50 a day, or about $75 a month.
Thank you, sir.
Yes, ma'am.
Okay. Well, Mr. Dalton, I don't see any other questions for you right now.
All right.
And so
I will leave with one thing. And
wait a second.
Someone else have a
there
question?
is
Wait a minute.
the other chairman, Powell.
The other chairman
has
Powell.
risen. Chairman Powell.
This son's a hell of a golfer, I'll tell you.
Thank you, Chairman Rice. Thank you, Jack. I sat there and I've listened, and let me preface some of my comments, or one comment I've got, because I've got one interest really about this. In 1991, when we started in the General Assembly dealing with DUIs and getting tougher on DUIs, over the years, one of the things that I saw in the committee, Motor Vehicle Committee, saw at that time, was that the tougher we got on, that we created a situation where we made people feel sorry for a first offender. The general feeling that we had, myself included, was first offender, you shouldn't have made the mistake, but we're not going to try to crucify you.
All right.
Second and subsequent, tough. And we got tough on it. Then we started seeing a lot of unintended consequences. We started seeing courts of jurisdiction that started basically pleading them down, and that wasn't right, because that wasn't real justice. It was mercy. But what we also saw was a lot of the problems that we saw. A lot of offenders who were out here driving without a driver's license because they could not afford it. They couldn't afford the DUI school. They couldn't afford the assessment. They couldn't afford the probation fees. They couldn't afford the higher fines that we imposed on them. They had to feed a family. Folks in the rural areas that Jay talked about. I'm in a somewhat of a rural area. We don't have public transit.
All right.
People are going to drive. They're going to take the kids to school. They're going to go to work, even if they have to skate around. And then law enforcement, quite frankly, a lot of the law enforcement turns a blind eye. They know these people. A lot of folks don't have a driver's license.
Certainly.
Now, I have never been a big supporter of the interlock. I mean, and that doesn't come as a surprise to a lot of people that's ever heard me talk about it in the committees. I do believe it's a tool that can be used on offenders. And I'm talking about multiple offenders, recidivism. One of the things that you said caught my attention that I might be interested in changing an opinion is that one of those unintended consequences is we have, in our society, none of us would have thought 25 years ago some of the stuff that we passed was going to come back in such a manner that have future repercussions. And what I'm speaking of is, you're a high school kid, you're a college kid, you're a young adult, you're a young professional. You get a first DUI, nobody ever thought that a college would not let you come to college because of a DUI.
That's right.
That's wrong. It's wrong to say that you can't get into a professional school, whether it be law school or medical school, because you made a one-time mistake.
Mm-hmm.
And it's not right that the United States military a lot of times will not consider your entry into the United States military because you made a first mistake. Now, the thing that you said that got my attention, it might make me consider a little bit of change in my attitude about this, is you said West Virginia has a program that on a first offender, that if you consider this extra cost and such as the interlock, that might be, that citation may not go on the books or might be expunged or whatever the process. Did I understand you to say that, Jack?
Yes, sir, you did. The program was put in, as a matter of fact, it was put in, and Senator Kessler was the one who did it. And we worked together again with the whole committee of people in West Virginia to come up with exactly how the bill should be done. And he got to thinking about that and said exactly the same thing that you did. So the law there says that if you choose, when you go into court and you ask the judge to go into this program, that you take the ignition interlock for a minimum of 6 months. If you complete the ignition interlock program with no violations, which means you haven't blown higher than .04 in the device, you haven't missed a running retest, you haven't missed an appointment, you haven't tampered with the device, after 6 months and you have perfect application of the device, then 6 months later you go before the court, and it's a legal thing. They say it's not expunged, it's simply hidden. So if someone queries motor vehicle about your record, it won't show up as a violation, as a drunk driving violation.
I guess what I'm asking, and I hear what you're saying on that, but once you're cited, there's either got to be an order of the court that disappears, or it's always on your record, and some school can always, or the military, or somebody can always see that you had a DUI.
Yes. Again, I will say, sir,
and those,
I don't know how it was done.
And that's something that
they make it legal.
Something if it ever went that far, that we would need to look at. But you know, I've been a great supporter, and we've got some great programs in the state. Our DUI schools, you know, I've dealt with these folks for years, and they do a good job. But I have, at this stage of my legislative career, I have reached a concern of some of the stuff that we've passed. Mm-hmm. Some of the stuff we've passed has done nothing except created a money trap. When we have courts that do referral business on some kind of DUI schools that they would call that aren't certified by the state. But if you go to this court, this program, well, then all of a sudden that DUI goes to reckless driving. Let me tell you something, that's not working. And, you know, we have to have a clear-cut system, but we also have to show a certain level of compassion. In our society today, and I hear, you know, when one of the guys was talking about 24/7 sobriety, that scared the dickens out of me. Mm-hmm. I think what they need to talk about is say it properly. It should be called 24/7 driving sobriety. But in our society, we're a society that allows and encourages people to be social drinkers.
That's exactly right.
People can make a mistake. Now, if they're actually drunk or not, it makes no difference because the standards has been set by the legislature. And it is a compassion and a mercy about these kids that can't get into, if they made that mistake, that they can't get into professional school. That disturbs me. And it's something I'd like to hear from some of the other folks out there that normally we hear the gnashing of teeth. I'd like to hear what their thoughts would be as this process goes on. Thank you, Mr. Chairman.
Well, thank you, Chairman Powell. And gnashing of teeth probably comes with lunch, but we're a couple of witnesses away from that right now. Appreciate your comments. Thank you, Jack. There's no more questions for you. Appreciate you coming down here and joining us today.
Thank you. We enjoy working with you, and anything you need, we'll be happy to supply for you.
Okay. We have two more witnesses that are on the schedule today. One's Captain Mark Hambert from the Georgia Department of Public Safety. Captain, come on up and talk to us about how it really is out there. Thank you for your service too. I should mention that. I was down at the awards ceremony for the Governor's Office of Highway Safety, and it was a proud day for a lot of the people that you work with on the patrol as they dealt with the issue of DUI and the number of arrests they made and the convictions they got and things like this. I think it was those guys were dedicated to the work that they do, and it was a good thing to see.
Yes, they are, and the department as a whole is dedicated to it. No matter what laws y'all put forward, we will enforce them, and we will do our best to get impaired drivers off the road. On behalf of Colonel McDonough, some of our strategic goals is to get impaired drivers off the road and to reduce fatalities. Something he's done as a strategy toward this, each trooper has been given, it's an A-RIDE program. What it is, it's a Advanced Roadside Impairment Driving Enforcement. It's a program that's about 2 days. Each trooper goes through it. They go back over their field sobriety test, sharpens up on that. And then also something we're seeing is prescription drugs. It's just, it's one of those, you have a lot of pain clinics, got a lot of people on prescription drugs, which nobody really thinks about, but they are also impaired too. And it provides an education for each and every trooper to know something's not right with this person. I'm not smelling alcohol, and it educates them on what to look for. But like I said, whatever law y'all instill, we'll enforce it to the best of our ability.
Other questions, Captain, for the Captain? I just have one, and that has to do with the ALS procedure. How much time does it take out of an officer's day when he's doing DUIs to deal with the ALS?
The ALS usually takes at least I'd say one full day of patrol. That includes getting ready. Just a regular road trooper, it might take half a day for him to be prepared to actually sit in there to go before the ALS administrator and to go through the hearing. Our DUI task force and things like that, they'll take a full day just to go through that because they'll have multiple cases, and it might go at least a full day on them.
Mm-hmm. Okay. There's a question from Representative Hightower.
This goes back to kind of when I first opened and was going over the introduction to some of the things we ran into last year. And one of the things that we had talked about was, there's a lot of things there that we talked about. One was possibly making the sentence for first-time DUI, even in refusals, a mandatory, or especially for refusals, make it the same as a second-time DUI offense, which means they would have a mandatory 4-month suspension. But in doing that, we would probably take away, like I said, some of the leverage that officers have at ALS hearings. How do the officers view that? How do they view the ALS hearings and using that tool to kind of help get someone to a conviction? And then also, after you touch on that, maybe touch on what we were talking with Jack about if we came up with a program that really didn't call for us to have the ALS anymore. Just your thoughts on those issues.
Well, the first offender, the ALS hearing it was put forth for the right reasons. When someone refuses, there is a reason why they refuse usually, and for whatever reason they're not obeying a lawful order or by law, and the ALS hearing kicks in because what we're having is refusals, and that was going to court, and I think it was brought forth for a good reason. Now the ALS hearing, it is used as a tool. It's a very good tool because they'll plead sometimes, and they'll work out deals, and it's a very good tool. Like you said, 12 months is a lot better than 4 months, and it will be a more powerful tool. But the ALS hearing also can be almost like an exploratory thing into the case also.
You think?
Yes, I think. So you can take something that's meant for good and it can be used. It's like a hammer. It can drive a nail. It can beat somebody's brains out. So either or, it's still a tool.
Thank you.
Chairman Powell.
Isn't it also the at one point in time an ALS suspension is because it's administrative, that you could under the law be administratively suspended because you refused, and then subsequently be found not guilty of DUI or whatever the case may be. But what I understand is happening now is that whatever happens in the trial court on the criminal, that then the ALS suspension is being merged with that. And so if I get, a 3-month suspension or something like that in court, then the Department of Public Safety is doing the same thing so that I'm not getting different kinds of suspensions. And so for all practical purposes, it's maybe not working like it was originally intended.
I think you're correct in that assumption because it is sometimes merged into the same suspension. And it's just it was a tool, I believe it was used or brought forward because of a refusal. Everybody was just refusing. And it was a good tool because, like you said, even if they were found not guilty in the court, they could still have an ALS suspension on their driver's license.
So, any other questions for Captain Mark? Okay. Chairman Setzler.
I don't defend these cases or litigate these. I know we've got some attorneys here that have, particularly Representative Hightower and Chairman Powell, see these things in their business practice. Could you help me understand if we were to pursue a process whereby, again, similar to what Mr. Dalton referred to, in layman's terms, help me understand how the flow would work if before you get your license back, say someone's arrested, they're taken in for DUI, so they spend the night in jail, whether it's before they get out of jail or whether it's before they get their license back, the next day or 2 days later or a week later, whenever they get their license back. If we want to get them their license back as quickly as we can, but in the context of an interlock regime, what do you understand the process would be? What are gates we could use to make sure that before the person goes and gets back in a vehicle, they have an interlock installed?
I mean, I hate to be a pessimist, but seeing what some people can do, I mean, other than just keeping the person in jail until an interlock device is installed, I mean, that's pretty much the only option we have to make 100% compliance. And that's if they're going to drive that vehicle. It's not going to stop them from driving any other vehicle either.
Good. What's your opinion about interlock being on one vehicle versus another vehicle where there's no interlock device and they get access to it and drive it? What's your experience?
Well, you'd be surprised how many people, that are caught for DUI, they're not driving their vehicle. They're driving their girlfriend's vehicle, their boyfriend's vehicle, or their mother or daddy's vehicle. So it's pretty much a rule. A lot of times they are driving their own personal vehicle, but you'd be astounded how many people will be driving someone else's vehicle.
Okay. Hopefully they're not the designated driver.
Well, you'd be surprised.
And Mr. Chairman, I asked the question because I do think it would be a great interest to the study committee to walk through that flow. What is required and when. I know oftentimes in law we don't get that prescriptive, but I do think whatever we pass in law needs to anticipate how that happens. And if there's something we need to prescribe to make that whole chain of events happen like it needs to, we need to be very thoughtful about getting it right. And the more feedback we get, I know Representative Hightower's got some thoughts on that perhaps, but I think we, in all I've heard, the mechanics of when that happens and how that's all sequenced has an extraordinary impact on its effectiveness. So,
well, I think that's a good question. We're at our next meeting. We are going to have the courts and the prosecuting attorney counsel and some others who can comment, I think, in the direction of the process a little bit more specifically.
Yeah, I think anybody in the audience that's lives this or sees other best practices could suggest, given Georgia law and others, there's peculiar areas about Georgia versus other states, really begin to suggest a process that could at least be considered by the committee. So.
Well, absolutely. I think that's a good point. Mark, thanks for coming today. Thanks for what you do for us every day.
Thank you, sir.
Appreciate it. Our last witness comes from AAA, and I am not sure that I got the name right here, but it's Sasha Marcinski.
Marcinchek.
Marcinchek. Okay,
Yes, Mr.
I'm
Chairman.
sorry. I knew I'd managed to screw that up someplace,
don't
but
worry.
anybody's got a Z in their name, I tend to get that screwed up.
Took me about 35 years to pronounce it properly myself. I did pick up on your not so subtle hint that I am the only one standing between you and the folks in this room and lunch. So I will do my best to certainly get through my material as well as answering questions.
You do whatever complete, thorough job you want to do.
Thank you, sir. I first want to thank yourself and the committee members for allowing AAA a seat at the table to talk about this important endeavor. And I'll talk a little bit, excuse me, today about our perspective in Georgia, as well as our perspective nationally. And as you mentioned, my name is Sasha Marcinchek. I'm the regional president with AAA here, which is part of the Auto Club Group out of Dearborn, Michigan. Since AAA was founded over 110 years ago, our pursuits have been driven by the desire to provide the safest possible travel conditions for the public at large, as well as our members. Through the years, we have advocated for many improvements such as padded dashboards, seat belts, airbags, improved road conditions, and recently the no texting while driving laws that passed. When we identify opportunities that will improve safety on the roads, we try to pursue those improvements. We have and will continue to maintain a strong relationship and presence within the state of Georgia. In 2012, our AAA Foundation for Traffic Safety did a survey and found that 9 out of 10 respondents felt that impaired drivers posed a serious threat to their safety. And while AAA believes there has certainly been progress made combating dangers of drinking and driving, there's certainly a lot of work to be done. And on behalf of our 770,000 members in Georgia, as well as all motorists in the state, we appreciate the opportunity, as I mentioned, to sit here and share our recommendation regarding ignition interlock devices, or IIDs, and specifically requiring the use of the IIDs when there's a convicted driving while impaired offender. The recommendation we make is consistent with research showing that interlock devices can reduce the rate of rearrest by as much as 67%. Making IIDs more effective than other prevention methods. Drivers with interlock devices also have fewer alcohol-impaired driving crashes than drivers who had their licenses suspended because of a DWI conviction. In fact, there were nearly 1.4 million people arrested in 2010 for driving under the influence of alcohol. This is more than 2 arrests per minute. Furthermore, AAA estimates that those 1.5 million stops only represent about 1% of the estimated 147 million folks that drive annually while impaired, and that's a self-reported study. While not all the additional 146 million drive while impaired, it's certain that many do and go undetected. And it's also likely that a number of those folks were previously convicted of DWIs. Each year, millions of people choose to drive while under the influence of alcohol, and sometimes with devastating consequences. Alcohol-impaired driving continues to be a significant public threat. AAA statistics show that during 2010 and 2011, there were 20,000 fatalities in crashes involving impaired drivers, an average of 1 fatality every 53 minutes, and it represented nearly 31% of all traffic fatalities in that same time frame. Drunk drivers also continue to claim the lives of the most vulnerable folks. In 2010, drunk drivers killed more than 200 children under the age of 15, and over half of them were actually in the same car as the impaired driver. And finally, drivers with previous DWI convictions pose a substantial risk of recidivism, as we've been talking about here today. Data shows that legally impaired drivers involved in fatal crashes were 8 times more likely to have a previous DWI conviction than drivers who had not been drinking. We think these deaths are preventable, In fact, research and experience shows that the use of IIDs will help keep alcohol-impaired drivers off the road. The national AAA position on IIDs is that they should be mandatory for all first-time offenders, even at the .08 blood alcohol level. We are encouraged and thankful for the efforts of Chairman Rice and House Bill 671. AAA believes that the House Non-Civil Committee's substitute to that bill, authored by Chairman Rice, serves as a reasonable starting point for legislation this year. In particular, in that bill, it eliminates hard suspensions and driving restrictions with high blood alcohol level convictions and refusals. It also, for all convictions at .15 and above, requires the offender to get an interlock device permit for a period of 12 months in order to apply for reinstatement of the offender's unrestricted license. And finally, for people who refuse, it allows the accused offender to obtain an interlock permit pending the outcome of the administrative license suspension hearing or trial. I do want to be clear that AAA we're not looking for the Georgia General Assembly to single-handedly tackle this challenge. Our track record at AAA shows that we have and will continue to put our money where our mouth is when it comes to saving lives. From developing in the 1960s one of the first rehabilitation courses for DWI offenders to our current AAA Tow and Go program, which provides a free tow and ride home for smart motorists who realize they've drank too much to drive, and has already taken tens of thousands of drunk drivers off the road. You have AAA's commitment to continue to invest in such programs, but your support of this legislation requiring ignition interlock devices for all convicted offenders will certainly reduce alcohol-related traffic crashes and save lives. Thank you.
Thank you, Sasha. Any questions for, yeah, we got one over here from Chairman Powell, the other Chairman Powell.
Not a question. Well, I guess it's a question. Do you mind furnishing us with a copy of your remarks?
I can certainly provide that.
I'd like that.
Yes.
Please.
I apologize I didn't bring that in advance.
Well, thank you. I don't see any other questions. I really appreciate it. I think you've covered a lot of ground for us, and we appreciate AAA's support of this committee.
Thank you, Chairman, and thank you, committee members. Enjoy lunch.
Okay, well, with that, excuse me. Look, thanks for everybody who's shown up today, and we do appreciate it. We're the committee and the staff are going to adjourn to room 605, which I think is right on the other side of the hall here, for lunch. We have a scheduled panel discussion wrap-up. I know that other people have to be on their way, and so at the chairman's discretion, unless there's any objection, I'm going to suspend on that, and we'll discuss this as we proceed. Okay, that terminates the day. Thank you, and we're going to adjourn. We're not going to come back. No.